Hi, this is Josh Blackman. Welcome to the 2020 Harlan Institute Ashbrook Virtual Supreme Court Competition. This year, we are arguing the case of Torres versus Madrid. This is match 12 of the semifinal round. Today, we're honored to have in our tournament Team 7857 with Brandon and Liza, and Team 7476 with Pedro and Yuvraj. Petitioners may begin whenever you're ready. You have 10 minutes.
May it please the court. My name is Brandon Fantine, and I, along with my co-counsel Lisa Frolova, represent the petitioner in today's case. Your Honor, on July 15th of 2014, the respondents, officers Janice Madrid and Richard Williamson, approached Miss Roxanne Torres, and fearing that they were carjackers, Miss Torres entered her car and drove off. In an attempt to stop her, the officers began firing at Miss Torres in her vehicle, with 2 bullets penetrating Miss Torres's back. Due to these injuries, Ms. Torres had to enter herself into the care of a hospital, putting her into a position where she could be easily arrested. Roxanne Torres was arrested the next day on July 16, 2014. Today, we are arguing 2 points. First is that Ms. Torres was seized the moment she was shot by the petitioner under the definition of a seizure outlined in California v. Hodari D. Second is that the aforementioned definition does match the original definition of a seizure under the Fourth Amendment.
To address our first point, an unsuccessful attempt to detain a suspect through physical force does constitute a seizure. The court has defined a seizure using the language of the Fourth Amendment multiple times. However, the most consequential definition of Justice Warren's definition from Terry versus Ohio. This definition found that within the majority of opinion of Terry states that a seizure is the restraint of liberties through physical force or authority. This more traditional definition of how to identify a seizure rests upon a seizure being something that restrains liberties. In the context of Terry, an arrest was considered a seizure because through police authority or physical force, a suspect has had his freedoms limited. This limitation on freedoms, or the limitation on what choices a suspect can make, is what constitutes the restraints of liberties, prong found in this definition of a seizure. The definition from Terry was further elaborated on in the court of Hodari D. In Justice Scalia's majority opinion on the case, a seizure was defined as being any application of physical force by law enforcement capacity that has resulted in the restraint of an individual's liberty. Using the same principle from Terry that a restraint on liberties is the severe limitation of one's choice, a seizure is simply broadened in Hodari D.
Counselor, if I could just interrupt you for a minute. What exactly was a holding of Hodari D?
That the intent and the physical force should be looked at in result towards the entire situation, and that the touching and of the individual matters. What force
did that case involve a physical seizure of a person?
Well, it was question on whether or not that the physical contact, it wasn't necessarily physical by hand touching like person to person, but it still was a seizure. As a seizure can be defined through the authority, the actual presence of the police officer, as well as the physical touch that is then that might be applied. It all then coincides with is a person's liberty in question. A seizure in the context of an arrest would be both the actual handcuffing or detaining of a suspect, along with the events that lead up to an arrest that involve the use of physical force, as the actions of police officers should be limiting a suspect's range of choices. For example, in the subcited...
Let me jump in and ask you a question. You focus quite a bit in your brief about whether there was any intent to seize the suspect. How, under your test, can we know an officer's intent?
Well, when evaluating an officer's intent, we're also evaluating what they do with that intent. A police officer can't simply be doing their job without intent. They have to have intent to stop someone, to protect the community. What they do with their intent is also what is questioned. We see that the police officers had an intent to either scare Ms. Torres or to to stop her as they were holding their firearms in direction towards her.
Well, let me ask you this: would it make a difference whether their intent was to shoot Ms. Torres's tires versus to actually make contact with her physical body?
No, Your Honor, because whether her vehicle was essentially surrounding her and was her means of excuse me, it was her means of moving. By seeing then, if the police officers were to shoot her tire, it would still have the same result of stopping her. If they had the intent to shoot her, it would be to stop her. And seeing as though that she had to go to the hospital as a result of this shooting, the police officers were successful in attaining their goal of stopping her and then arresting her. As applied in the cases present, Ms. Torres was seized the minute she was shot. Because
I have a question for Mr. Fantine, if I could ask you, Brandon. Brandon, if a police officer walks behind you and then taps you on the shoulder, is that a seizure?
Yes, Your Honor, that would be considered a seizure, as the police officer intended to restrict your liberties by stopping your movement.
How do you know there was that intent there?
Your Honor, when somebody taps you on your shoulder, they're trying to get your attention. They want you to turn around and look at them or pay attention to whatever they want from you. It is implied that they want you to stop and talk to them.
But doesn't that go back to Justice Bashop's question about intent? How do you know what the officer's intent is?
Again, Your Honor, the intent is discerned through the actions of the police officer. So when the officers in this case began shooting at Ms. Torres, it showed that their intent was to stop her from moving, because as seen in prior cases, when an officer begins shooting at a car, that shooting is intended to stop the car.
Can I proceed?
Addressing our second point, the definition from Hodari D directly lines up with the original definition of a seizure under the Fourth Amendment. In James Otis's arguments against writs of assistance, he was arguing how the British writs of assistance, or general warrants, were inherently wrong. His main argument was that these warrants forced any and all people to submit to police authority, and that submission limited his right to life, liberty, and his property. Hodari D follows a similar idea. The previous definition created by Justice Scalia was that a seizure occurs when a suspect's liberties are restricted because they are either...
If I could jump in, how do we know Justice Scalia was right? He wasn't always right. Maybe he was wrong. What evidence we have that Justice Scalia was correct here?
Well, Your Honor, the most important precedent and the most correct precedent in the sense is the one that matches the meaning of amendments as they were written. In this case, Justice Scalia's opinion does match the original meaning of a seizure under the Fourth Amendment, as both the original meaning discerned by James Otis was that a seizure is a voluntary or involuntary submission to police authority that restricts freedom of liberty, freedom of life, or freedom of property. Justice Scalia said fundamentally the same thing, that submission to police authority through the restriction of freedoms constitutes a seizure.
All right. You may proceed, Counselor.
At a fundamental level, both the argument that James Otis made and the argument in Hodari D rest on the fact that seizures must limit liberties in some capacity. This prong of the definition can also be seen through other ways a seizure has been defined. In Terry, a seizure occurred when liberties in general were restrained. In the dissenting opinion from Brower, a seizure occurred when a reasonable person does not feel free to leave, meaning a reasonable person would feel that their liberties of movement have been restricted.
Counselor, how long does that restraint have to last in order for it to be considered a seizure? So say, for example, in your case, you have a person who was not in any way deterred by the fact that shots were fired and was able to escape for a day. What if you have somebody who, the tires were shot out and they were immediately stopped, but then fled on foot? How long does that liberty need to be restrained in order for it to be a seizure?
Your Honor, the liberty can be restrained in a single second. It does not matter how long a restriction of liberties lasts, as long as that restriction of liberties results in some type of arrest or detainment or something like that. In this case, even though the restriction was a shooting, that directly resulted in having Ms. Torres go to the hospital because she no longer had that freedom of choice. Her liberty to choose where and where not to go when fleeing was restricted, and she was able to be arrested. Your Honor, even if an attempt to immediately detain a suspect through physical force is unsuccessful, a seizure still occurs as long as some freedoms are restricted by that application. This quality of a seizure outlined in Hodari D directly lines up with the opinions of James Otis that would come to inspire the protections of the Fourth Amendment, making Hodari D's definition of a seizure fall within that original spirit. It is for these reasons we pray that you rule in favor of the petitioner and reverse the lower court's ruling. Thank you.
All right, excellent. Thank you so much, counsel. All right, I'm going to reset the clock. If the respondents can please come forward. You have 15 minutes and begin whenever you're ready.
Your Honors, and may it please the court. I'm sorry, Your Honor, the clock hasn't started. We can see it now. Okay, thank you. Your Honors, and may it please the court. The respondent, my name is Yuvraj, Tuli, and my co-counsel is Pedro, Ribeiro. We'll be separating our time based on our two arguments. We have two unique arguments. Our first argument is the interpretation of the word seizure through a colloquial, legal, and linguistic sense requires that physical force be successful to constitute a seizure. Our second argument is that the original meaning of the Fourth Amendment through the word seizure and the original practice and understanding of the Fourth Amendment support that physical force is required to be successful to constitute a seizure. My co-counsel will address the first argument.
Your Honor, we believe to settle this case, we must also look at the colloquial definition of the word seizure. Colloquially, seizure is defined by the taking possession of person or property by the legal process. It is evidence that there was no unreasonable taking of possession of person, as the petitioner was not possessed. She was not taken into custody, and she had the liberty to go wherever she wanted to. The colloquial definition of the word is key to determine its usage within the Constitution. Despite being a legal document, its origins are not limited to those with legal pedigree, and we still must look at how it's used today. However, the legal definition and legal scholarship also has been categorical that for the court to rule the seizure unconstitutional, a full apprehension of goods and persons must be achieved by the arresting officer. There's legal consensus that attempts must be successful in order to constitute a seizure. Dictionaries say that seizure means the taking by law enforcement officers of potential evidence in a criminal case, and NOLO defines seizure as the taking of physical evidence of property by law enforcement officials. Seized evidence can include taking blood for a blood test and pounding a car used in a robbery. In this case, the officers could not do anything else further with Ms. Torres as she was not detained.
Counselor, if I could interrupt you just for a minute. In your mind, what is the strongest common law authority you have to support your position?
Sorry, could you repeat that, Your Honor?
What is the strongest common law authority you have to support your position?
My partner will be arguing a little bit more about common
well, then
law,
you can switch now. Yeah, we kind of go in our order, not yours. So your partner can jump in if he wants.
I don't know where my partner went.
All right. Well, you can continue your remarks then.
So having ownership of something. Black Law Dictionary likewise defines search and seizure as searching and taking property of fatal criminal. Effectively, all legal and colloquial dictionaries define taking and possessions as prerequisites for interaction with law enforcement to constitute a seizure, which did not happen in this case. We also argue that seizure, in the constitutional sense, is a prerequisite to search. The original intent of the Constitution was not only to stop apprehensions and arrests, but also to define seizure as a prerequisite to search.
So Counselor, if I ask you a question, in Hodari D, what exactly was the holding of Hodari D?
In Hodari D, we established the basic definitions for an unreasonable search, and as the opposing counsel has said, that might support Ms. Torres's argument. However, there's a few other cases that we believe would constitute a seizure as being a necessity to apprehend the person, especially as a means to search them.
So let me ask you a general question. in this case, they shot at her 13 times, right? Just let's be realistic here, right? They shot her 13 times. How is that not a seizure, right? How is that? How can you possibly say shooting someone 13 times is not a seizure?
Your Honor, we're just really saying that for someone to be apprehended, the officers must retain full control. So they must take her to detention or arrest her. In this case, even if she was shot 13 times, she retained her liberty to move and to go really wherever she went. There's no real subjective view of intent or anything in our argument. It's just, were the officers able to take full possession of the person, and were they able to ask questions or take samples, etc.?
Counselor, let me ask you a policy question then. Do you have any concerns that if the court adopts your test today, that it's going to encourage people to flee police and actually make police work more difficult?
Your Honor, I don't think it would have that sort of effect, mostly because it's then the interpretation of it would be dangerous to flee the police in a court, as we've seen by cases of Mrs. Torres where she was shot at, and it would also would heighten the charges levied against them. I sincerely don't believe there would be any long-lasting effects on whether a criminal would be fleeing or not, because the consequences would be even stronger if they succeeded in fleeing.
All right, are you back here, sir?
Yes, I'm sorry. There's power outages in Florida, like power surges.
It's okay. All right. I'm not sure how you want to continue, but
Yes. I'll go to my part. So, Your Honors, the second argument is the original understanding of the word seizure at the time of the founding, and we contend that physical force is required. In colonial Virginia, which was one of the most consequential colonies to the Bill of Rights, and it acted as a laboratory democracy, it's quoted at general warrants whereby any officer may be commanded to seize a person or persons not named are grievous and oppressive and ought not to be granted. This provision implies that seizure of a person means that said person is under control of the officer. Furthermore, colonial Pennsylvania, in its amendment, the 10th Amendment of its Declaration of Rights, allows the officer of the peace to explicitly seize a person, similar to the Virginia one. In this case, the word arrest is akin to the word seize, where person or object becomes seized when it's under the control and full direction of the law. Dictionaries at the time of the founding illuminate this view that someone or something is seized when it's restrained and the possession is transferred from liberty to a legal authority. It requires
this. If I could just jump in for a second. What English cases do you think are most relevant to our discussion here? Cases from England. I appreciate the colonial authorities, but I think there might be some relevant cases from England.
So, Your Honor, specifically the practices of England in seizure, and especially before the America declared revolution, where the British ships were seized, and they were seized as they were taken full possession of, illuminate this view. They weren't simply touched, they were taken over, and the authority was transferred to the British monarchy. And that's a basic example that we rest our case on, that seizure means taking possession
Any
of.
specific case names that you've come across?
Your Honor, at this moment, I can't recall a specific case name, but the general trend of the practices from English Britain to this day means that seizure is taking possession of. And most importantly, the original meaning, especially in the colonial era, where the original thought is based on and which wrote our Constitution, is the most important factors of the originalistic understanding.
Let me ask you this then. At what point have we taken custody or possession of a human being? So in this case, if shooting 13 bullets at a person doesn't qualify, what would in this situation? Can you give me an example using the facts of your case that we might have stopped the analysis and said, yes, she has been seized?
Yes, Your Honor. So in this case, Miss Madrid fled away in her car. The officers could not control her. She could have gone into the community and done other acts. The officer had no control over her. See, for us, a seizure means when the officer is able to direct the person's actions. They're able to control them. They're under their responsibility. They're under their purview. And seizure means in our contends the officer of the law is able to control the person's movement. They're able to restrict its liberty and prevent them from moving or anywhere. It means that the person has to do what the officer tells her person to do under its authority.
So then a person who continually resists would not be seized. So let me give you another example. Say that she had stopped the car, she had gotten out of the car as though to comply, and as soon as the officer came within reach of her, she decided to take off. Was there a seizure in that situation?
No, Your Honor, because the person took off. The officer could not control her actions. If the officer is following her, trying to seize her, like for example, police chase, as you said, the officer's trying to seize that person. It's not seized. Basically, in a seizure, when the person has cuffs on their hands and the officer is controlling them, is a seizure. The police chase doesn't constitute as a seizure because the person can hit someone in the road and that person is responsible for that and not the officer because she's not under the control of the officer at that moment.
But counsel, isn't this a weird rule you're asking for where, if you shoot a person, they go down right away, they can sue you. But if you shoot a person, they're Wonder Woman, they don't go down, you can't sue them. Isn't that like a strange rule you're advocating for?
Your Honor, our rule is simple that the person has to be in possession of the officer. For example, if an officer uses deadly force and a person submits to it because of deadly force, they're on the ground and the officer goes up to them and restrains them, that's a seizure. The person is under the control of the officer and the person is
But if in this case, the plaintiff was like a normal human being and was shot and stayed down, we wouldn't be here. You would lose, right? How is she, in other words, how are you rewarding someone for not basically passing out from a bullet by letting they can't go? In other words, they passed out from the bullet shot, they go to court and they win. If they manage to survive the bullet shot, they don't win. How can that be your rule?
Your Honor, our rule is specific in a broader sense that the officer is responsible for taking possession. To be constitute a seizure, has to take possession of the person. If the officer is unable to take a possession and has to chase the person, that's not a seizure because the person is running away from the officer and the officer cannot control the person's action right now. What we're simply advocating is there has to be successful possession. For example, in documents, to seize a document, the officer has to take them into possession to review them based on probable cause. That's a proper seizure. Here, we're advocating.
Aren't documents different than people? Is there a reason? Why should we have the same standard for documents than we do for human beings?
Your Honor, you're correct. Documents are different than human beings. What we're advocating for is just as example that there has to be possession to control the person. If a person's, for example, car chase, if the police officer is following them in a car, that's not a seizure. They're still trying to obtain the arrest of the person. What we're advocating for is when the person is fully under the control and direction of the officer, that's a successful seizure and not a mere touch. For example, if an officer does a mere touch and the person still escapes and does heinous acts, the officer is not responsible, the person is. And the person has to be under full control of the officer to constitute a legal seizure under the Fourth Amendment.
Would you agree that the Fourth Amendment is meant to protect people against the government generally?
Yes.
Okay, then how does your standard that you've articulated protect people against government action?
Your
Honor, sorry.
Counsel, please go ahead.
Your Honor, I think the idea of the argument that we are making is the seizure of the person must be complete so the officers can take further action, such as searching the person or making sure there is no further threat. The Constitution is meant to protect the people against governmental actions, especially unreasonable searches and seizures. I think it would be hard to say that the search of the petitioner was completely unreasonable, and there's still a standard of protection even if our rule is applied, because unreasonable seizures would still be forbidden.
Do we need to decide in this case if the search was reasonable?
I think that would be an easier avenue to rule in our favor, but we do not, because we believe that a complete apprehension would be necessary. But if we did decide what if the search was reasonable or not, I feel.
But if there's no seizure, does it matter if it was reasonable or not?
Well, in that case, we'd be deciding if an attempt of seizure would be would be reasonable, really. And even if the petitioners are correct, then as long as we prove that the attempt was reasonable, or in their argument that the seizure was reasonable, then there really would be no case.
Okay, thank you.
Your Honors, to continue, as we reiterated, that if we contend that the text of the Fourth Amendment, the original public meaning, suggests that possession is required to constitute a seizure. To address our friends on the other side's argument with RED, we contend that we contend that furthermore, the court in Hudaridi held that an escaping suspect is not seized unless the legal authorities apply physical force to suspect. However, this case is different from Hudaridi. The facts of this case are different to Hudaridi. The court never reached a conclusion of Hudaridi whether physical force has to be successful. Hudaridi's fact pattern is different from our case. It did not involve any physical force. And with that, Your Honor, we rest our argument in which we believe a seizure in both a colloquial sense and the original public meaning sense requires taking possession. Thank you.
Thank you so much. 5 minutes now for the petitioners. You may begin whenever you're ready.
May it please the court. To address counsel's first point, a person does not have to be taken into direct custody for a seizure to have occurred. Pointing to the examples of Tennessee v. Gardner, Brower versus County of Inyo, Brenlin versus California. In each of these cases, the persons involved were seized before they were taken into custody, as well as the moment that they were arrested. In Tennessee, we see that the shooting of a suspect was unanimously agreed upon as a seizure. In Brower, we see that forcefully stopping a suspect before an arrest is also considered a seizure. And in Brenlin, we see that a passenger who is not arrested or detained is seized at a traffic stop.
Counsel also used a law dictionary in their argument to justify what a seizure is defined as. However, there are many ways to define a seizure, as demonstrated by California v. Hodari D, where a seizure is defined as the forceful restriction of one's liberties and the submission to authority. The most reliable of these definitions is not one found in a dictionary, but one that lines up with the intentions of the founding fathers. And that definition is the definition of a seizure, that any moment a suspect's liberties are restricted or begin to be restricted, a seizure has occurred.
The Virginia Declaration of Rights that counsel addressed in their second point does not define a seizure in any manner. The document states that a seizure of any person or persons not named is an oppressive action. This in no way defines what does and does not constitute a seizure.
Furthermore, the respondent also claimed that the Pennsylvania Bill of Rights used the common law definition of a seizure, a definition that included the idea that if a felon escapes, they have not been seized. Yes, it is true that if
Counsel, I think we've covered a lot of the historical evidence, on both sides. And your colleagues on the other side also mentioned colloquial definition of a seizure, which seems to me, frankly, to be their strongest point. Doesn't it seem odd to you that you're arguing that Ms. Torres was seized, but yet she still drove 75 miles to a hospital? How do you reconcile that apparent tension?
Your Honor, even though Ms. Torres was able to drive an extra 75 miles, she was not able to continue fleeing and escape the police successfully, because when she was shot, she was forced to attend the hospital at some point. If the officers had not shot Ms. Torres, she would have never attended the hospital, and she would have never been put in a position where she had to be arrested.
So let's switch it up. So let's say she never attends the hospital, but she was still shot. Has she been seized then?
No, Your Honor.
So your argument then, playing off my co-justice's hypothetical, is that if the bullet had grazed her shoulder instead, and she never had to go to the hospital, that she would not have been seized, even though she had been fired at.
Yes, Your Honor, that is completely correct. Because Ms. Torres's liberties were restricted, the choices she could make after she was shot, she was seized. If these choices were not restricted, she would not have been seized.
Let me give you another example. Let's say they shot her and the bullet just grazed her. And then 6 weeks later, she came down with tetanus and had to get a tetanus shot. Would that be a seizure?
Your Honor, proximate cause would have to be proved by that point, because the temporal proximity would be so abundantly large that it would have to be proven that the bullet caused the tetanus infection.
Like easier, she got lead poisoning. like in a mobster, right? She came out lead poisoning 6 weeks later, and that was only exposure to lead. Could the police be sued for a seizure at that point?
Your Honor, if it can be successfully proven that that specific bullet caused the lead poisoning, then yes, she would have been seized.
All right, counsel, you may proceed. Thank you. My crazy hypotheticals. Go ahead. You have about a minute left.
The belief that counsel alluded to that a person could not be seized unless they willingly submitted to an officer's authority during the colonial era is simply untrue. The respondent has 1, no document to support this claim, and 2, the common sense that dictates that an officer of the law, when arresting a person, can use physical force to make them submit and go into custody. It is for these reasons that we pray that you rule in favor of the respondent and reverse the lower court's ruling. Thank you.
Okay, thank you so much. All right, everyone, you can come back on camera. I'll turn this dreaded clock off. That was fun. Wasn't that fun? I had a lot of fun. And I gotta say, to my friends in Florida, you're dealing with some unusual situations. Your power goes out, you're in an airport. I know that's not easy. You want to do one part, your partner, couldn't get on. So I know that that's hard. I think you handled it with grace, with poise. You didn't panic. You didn't freak out. You didn't go, oh my God, what am I supposed to do? You kept going, which is wonderful. And to my friends in Texas, I know you're in the same room, but you're at least 6 feet apart, I suppose. But still, I think you handled it smooth. I couldn't tell you had any difficulties handing one to the next. COVID is really tweaked how we do this competition. But I think you guys did a wonderful job. Now some specifics for petitioners. We gave you some really hard hypotheticals, right? Because you're taking a position that is a little hard to defend, and it's not perfect. And I think tapping on the shoulder, God, lead poisoning took me 12 matches to come up with that, but lead poisoning, right? Proximate cause. I did not know what proximate cause was. I was a first-year law student, so good for you. That's good. Even know what proximate cause is. It's a term from torts that discusses whether it's liability, but it's a really good term. And Lisa, also, you handled some of my questions pretty well. I tried to throw you off your game, and what I like most about all 4 of you is you stuck to your guns. You had your game plan. You came here to take a certain position, and no matter what I said, no matter what I did, you didn't deviate an inch from that. I think that's important, because once you deviate an inch, oh, I'm going to tear you apart, right? It's like, well, you said this now, but 5 minutes ago you said that. How can you reconcile? And you're done. You're toast, right? You're gone, because you can't recover from that once you switch positions in front of the judge. So that's a very good thing all of you did. I think you had all good command of the case law. You had good command of the common law authorities. You had different dictionaries you were citing, which is helpful. I think you each had flexibility. You have to know you have to know your partner's role back and forth. So even when Yuvraj your power went out, Pedro's like, well, that's not my part, but I'm gonna do it anyway, and that was good. Just run with it and do the best you can. It's like if you think about like you're going to acting or theater, there's an understudy. And the understudy has to know the entire role of everyone in the play, basically. You are your own understudy, right? So you have to know your role, you have to know your partner's role, and you have to be able to just roll with the punches, so to speak. We were asking you hard questions, so we think you can handle them. I've been doing this competition now for 8 years, and it keeps getting harder and harder, better and better and better. Students keep getting more and more prepared. They bring their games. And I can tell you, you two, what are you, 16, 17 years old? You could be in law school. You could compete in a law school moot court competition. I have no doubt in my mind. If I just dropped you in a law school tomorrow and I put a mask on you, perhaps you'd be able to compete in any moot court competition. You're that good. So you should be very proud of yourselves. I know my friends in Texas has good coaches. I know Trish is a good coach. So be very thankful for your coaches, because they're doing a really good job to help you along. But this is wonderful. Thank you so much. I hope Sam and maybe Curtis have some other feedback that they can give for you.
Yeah, really nicely done, everyone. It's difficult to play off that dynamic when you're working with partners, especially. I think you both did a really nice job of making sure you knew exactly where you needed to focus your attention. How you were dividing the argument seemed really smooth to me. And you all were really good advocates for your position. I know sometime when you're in the advocate's seat and you're getting these questions, you hear the judges ask one side questions and you think, oh man, they really don't buy it. And then you hear them ask the other side questions, like, oh, they don't buy that either. So it's a testament to the quality of the argument when you can't really figure out where the judges stand on it. And I also think you guys did a nice job when we tried to twist those hypothetical situations on you, and we change one factor, we change a circumstance, adapting and really taking a strong stance on it. I think that's good, especially, you know, at the end of the day, you're advocates for your clients. So it's a good thing to keep in mind.
Curtis?
Yeah, I think the hypotheticals, the more of this I do, I think the hypotheticals are the trickier kinds of questions, because it's always you give a good answer and then they change the hypothetical and they just make it harder. It's hard to win. But I thought you all did a good job of just sort of rolling with the argument wherever it went. And it's tough to maintain the appropriate balance of being flexible, but also to try and return back to your points, because you've got a couple points you want to make throughout the argument. And I think you're gonna obviously keep working on that for as long as you do stuff like this. But I think you did a very good job of it still. So it was fun to judge. I thought it was a quality round. Thank you.
Very good. At this point, I usually like to say, are there questions for you? Do you have anything you want to ask us?
No questions. We just wanted to say thank you.
I appreciate that. Are any of you interested in perhaps law school, thinking about becoming an attorney? Yes, all of you? Oh, that's wonderful. Well, I emailed Trish, and I also emailed you guys in Texas. I teach a constitutional law class during the week, Mondays and Wednesdays at 12:30 Eastern. I'm sorry, 2:30 Eastern, 1:30 Texas time. If you want to come this week to sit in my Zoom class, you're welcome. So I don't know where you're flying to, Pedro, but if you have Wi-Fi, you're welcome to attend. I think you'll like it. You'll see how law school class is, and you'll see that the types of questions that I ask all of you are the sorts of questions that you would get in a law school environment. So you are well on your way. Oh, wow, look at that. You got a prop.
And you signed it for me. So you were really nice to sign it for me.
I did sign it for you. That's you. I know who you are. Now I remember. Okay, it just clicked. I've been doing these for like 12 hours. I'm exhausted, but that's right. Well, I'm so glad you liked the book, and hopefully you enjoyed it, and you're getting a good thing. Trish, how's everything with you? Good? Your class is going well?
It's, good in the strangest year we've ever had, any of us, but it's been great.
Last year was strange. This year's stranger, I suppose.
It's true, but having students like this who are enthusiastic and take initiative to participate in programs that you were able to still creatively offer is just fantastic. So thank you for finding a way to make this still work.
Yeah, it's tricky. But we really did make it work, and I'm very proud. We'll be releasing the scores tomorrow. We'll let you know what happens next, but all of you did wonderful. I'll put my email address for you all in the chat. If you want to email me at anything, you're welcome to message me. I'm happy to answer any sort of questions that you may all have. All right, anything else in your minds, guys? All right, well, with that, if the students and coach can sign off, I'll talk to the